All right, Brian, as trial lawyer, I want to come to you first with this. When we were talking about this, I was indicating that before the cross happened that, man, you got to be really, really careful with cross-examining this young daughter. It's a heartbreaking scenario. She's taken away from her parents. Her mom died by suicide. They're arguing connectively, causally, as a result of this incident. What are your thoughts about that? And legally, is there causation here? Can you explain that to our audience, what that means, and is it strong enough here?
Yeah, so first I thought the cross-examination was great. You come in and out, you're talking about the letter, the ability to connect with the family. You're not attacking this witness who clearly went through something horrific, not only in the sickness, the treatment, but also the loss of her mother, and you get what you need. In terms of causation, I'm probably going to give a lot of lawyers PTSD by bringing this up. I shiver every time I think about it. But most of the country as lawyers, we learned this case called Palsgraf v. Long Island Railroad. And it's what we used to learn was called causation. It's a kind of like a domino effect that one thing happens to the other, and then ultimately you, either the defendant or the proximate cause of the plaintiff's harm. The best way to explain this is the case, and if I mess it up, Bob, please correct me. But a man is running to the railroad to try to catch the train. He falls. Two railroad employees catch him. In him catching him, his package drops. Inside of his package is fireworks. The fireworks go off when they drop, and on the other side of the train tracks, those fireworks hits a scale, and that scale falls over and kills, I think, a mother. The jury found for the mother, saying, yes, this whole domino effect caused the mother to die. But the case was reversed because I said, you cannot foresee that. And the reason why I bring that up is because I think the hospital, even though I think they really messed up by not properly investigating this and seeing that the proper medication was being given and there was no forms of abuse, I think the hospital has an argument to say, this is Palsgraf. Something really horrible happened, but we're not the proximate cause of it.
Palsgraf. Okay, well, you know, just so the audience is clear, because it's probably not visibly obvious to you, Brian heard about the Palsgraf case less time than I did, which was a really long time ago.
We all learned in law school. Not too long, Bob.
But I think you did a pretty good job with that. Ken, good point. That's what causation is. Great, that's the case. That's the case that people talk about. And there were a lot of moving pieces in the Palsgraf case. Is it so far, I think the plaintiff would argue, to believe that causally speaking, when you take a child away from their parent who is sick, who is ill, who relies upon them for nurturing medical care, that it could cause emotional damages to a loving and caring parent when the state and the hospital rip that child away for no reason? I think that causation's a little, Brian's point's a fair one, but a little different than someone running down a platform with a box that explodes, that hits a scale and knocks it over. That could be a little tenuous, a little extended, but is this that kind of case?
Brian's description was great, and actually learned something here today. So Brian, kudos to you for teaching a professor something new. I really enjoyed that. But from my experience as a police officer and working in that fashion, we had the good faith doctrine that we worked with, and mandatory reporting, and so we look at situations, and when we thought that abuse was present, then we would present that information to the appropriate authorities. But then the appropriate authorities need to do an adequate and responsible investigation in order to determine whether or not the facts are substantiated or not. Mm-hmm. And I don't think that happened here in this case. And it sounds like that they fumbled the ball with that and in that. So that kind of brings us back to this causation thing. Does that then perpetuate it to the point of causation, right, in not doing an adequate investigation,
right,
or the excuse from it?
Right, and of course in a civil case we always must remember the standard of proof is lower than the cases we typically handle here. It's a preponderance of the evidence, which means they have to prove that it's more likely than not, just over 50%. All right, on the civil trial points and Palsgraf in mind, we're going to take a quick break. We'll be right back.